I am Dr. Neil Grossman. I chair the Psychology and Law Committee of Suffolk County Psychological Association. In my practice, I specialize in clinical and forensic psychology. In working with professionals and my patients who are divorcing, I have identified a critical concern. Often people start their divorce without giving enough consideration to the process they will use. Many times, this uninformed decision causes hardship in the divorce. In order to understand the important differences in the three major divorce models, litigation, mediation, and collaborative divorce, I have invited a panel of my colleagues to explain these divorce models so people can make a smart choice. Okay, I'd now like to ask the panel to introduce themselves.
Hello, everyone. My name is Jackie Caputo. I'm an attorney on Long Island, specializing in collaborative divorce and in mediation.
Good morning. My name is Catherine Canaday. I'm a mediator and collaborative attorney working in Brooklyn, Manhattan, and on Long Island.
Good morning. My name is Teresa Ambres, and I am an attorney and mediator practitioner working primarily in Long Island and Queens.
Hello, my name is Bob Raymond. I am a clinical and forensic psychologist, a member of the Suffolk County Psychological Association, and I have offices in New York City and on Long Island.
Okay, the disclaimer. This video podcast is meant to provide information about divorce. The information provided is educational and general in nature. If legal or psychological advice is needed, please consult with an attorney or a psychologist. Okay, now Bob is going to talk about emotions in divorce.
Thank you, Neil. Let's acknowledge that divorce is an upheaval. That's because when a couple marries, there's the expectation of a long, happy, and enduring life together. Divorce means marital vows of togetherness are shattered. Life is upended, changed, disrupted, and typically this is accompanied by a wide range of feelings. For one thing, trust is lost. And with that loss, there can be feelings of anger, betrayal, hurt, sadness, resentment, fear, uncertainty, confusion, guilt, and a range of other emotions that contribute to fueling the divorce process. Not everyone going through a divorce has the same feelings, but everyone going through a divorce has very strong feelings, which have a direct influence on how the divorce process occurs. For some, there is enormous upset and regret. Others experience guilt over what they have done, or perhaps what they have not done to enable the relationship to thrive or to cause the relationship to sink. Loss is central to the experience of divorce. Loss of a stability, loss of a balanced relationship that has kept one steady and steadfast. For the person initiating the divorce, there can be guilt and shame, self-blame and self-criticism. For the spouse who is reluctant to divorce, there can also be self-blame and self-criticism, though often accompanied by sadness, anxiety, depression, despair, rage, and even a desire for vengeance. So when we say that 90% of divorce is emotional, we are saying two things. One, that the reasons for divorce are almost always emotional. 90% of people who divorce do so because of emotional factors. And two, during the divorce procedure itself, approximately 90% of the process is based on and fueled by emotional factors. The feelings of anger, guilt, hurt, sadness, fear, and insecurity, to name a few, propel the way the divorce process plays out. And as you might imagine, these feelings frequently make reaching a settlement agreement very difficult. So the question is how to counter this. The answer, 1, have a good support system, family, friends, and colleagues. And 2, choose the best method for your divorce, the method that will meet your needs and keep you balanced and healthy. So now let's hear about the 3 options available for getting divorced.
Okay. There are 3 ways that people divorce. In litigation, each person hires an attorney. They go to court trying to reach a settlement. If they can't reach an agreement, there's a trial, and the judge decides the details of the divorce. In mediation, people hire a mediator who helps them reach an agreement on the details of the divorce. In collaborative divorce, each person hires an attorney, and working together with other specialists, they reach an agreement on the details of the divorce. Now, Jackie will start with a discussion of litigation.
Thank you, Neil. Yes, I'll provide a quick overview of the litigation process with the goal of helping you to understand how it really works if you choose the path of litigation, which is the traditional courtroom process that I think most people probably imagine when they think of a divorce. I'll discuss the steps in the litigation process, the reasons why people may choose to engage in it, and lastly, the concerns with litigation. In litigation, each spouse will retain his or her own attorney. It is possible to represent yourself and proceed without counsel as a pro se defendant or plaintiff, but usually the parties are each represented by an attorney of their own. The spouse that commences the court action is called the plaintiff and must serve the other spouse, who is known as the defendant. An action may be started by purchasing an index number and filing the initial basic pleadings. Or if there is an urgent need for immediate relief or court intervention, one may take the additional step of filing a motion for pendente lite relief. This is much more time intensive for the attorney, which makes it more expensive, but in most cases is not necessary. Typically, the attorney will request a preliminary conference, and then in the months and/or years to follow, there will be a series of compliance conferences. The spouses and their attorneys will appear in court each time, but very often the conference is not held on the record in open court. Instead, the couple waits in the courtroom or in the hallway, while just the attorneys attend the conference in the judge's chambers, sometimes with the actual judge and sometimes with the judge's law secretary. In a post-COVID world, however, most matrimonial parts are continuing to conduct virtual court appearances, where it's usually just the attorneys that log on for a virtual appearance with the court, without the presence of their clients at all. If there are children of the marriage, the court may appoint an attorney for the children. The court also has the ability to order a forensic evaluation. There are formal methods of discovery, which may be used to try to compel the spouses to provide information. Attorneys may send demands to one another or use interrogatories, depositions, or subpoenas to obtain various documents. Motion practice may ensue if there are issues that arise which cannot wait until the end of a trial to be decided. If so, a written motion will be submitted. The other side will have an opportunity to oppose it or to bring a cross motion. Ultimately, the court will render a written, binding decision. In litigation, the parties and their attorneys may try to settle the matter outside of court. Negotiations may take place at any point. They may conduct a 4-way settlement conference where the attorneys and the spouses discuss the terms of settlement. But that is voluntary and requires the cooperation of all involved. If the spouses and their respective attorneys are unwilling or unable to settle all the details of the divorce on their own, then ultimately there will be a trial and the judge will determine the outcome. Moving on now to discuss why people would choose litigation. Sometimes people select litigation because there is a legitimate need for immediate relief or assistance of the court. For example, in the instance of domestic violence, where a spouse and/or the children may be in danger and require protection of the court. Or perhaps if support is being withheld and an order of temporary support is necessary. If a spouse or an attorney are not voluntarily cooperative, then one may have no choice but to go directly to court. Sometimes people simply prefer to be represented by an attorney. They may be intimidated by the process and feel that they need the assistance of counsel. They may feel that they are not able to speak for themselves or not knowledgeable about the law. A person may feel that traditional courtroom litigation is the only way to seek justice or to shame or punish the other party for their wrongdoings during the marriage. They may be motivated out of spite or revenge to make it as difficult and expensive as possible for their former partner. Very often, though, I see that people just think this is how it's supposed to go, and they don't know about alternative dispute options. And that is very unfortunate. In my practice, when I consult with a client, I always explain the alternative methods to them because there can be many real concerns with litigation. And I'll highlight a few of those concerns now. Litigation is adversarial in nature and can dramatically increase conflict in a family. Tensions are already high in a family that is facing divorce, and that can only be instigated further by an us against them, winner and loser mentality. That's only natural in litigation. In litigation, couples don't have control over the process. They are at the mercy of their attorneys and of the court. Timelines, decisions over finances, homes, businesses, and children will be made by total strangers rather than the parties by themselves. And like I said earlier, the reality is that much of the proceedings may take place outside of their presence. Clients are often told what happened in court after it's over and without their input. Cookie cutter outcomes are common. It's not that the court doesn't care or have compassion for the families that come in, but they do not necessarily have the time and resources to delve into all of the nuances of a family's dynamic, schedules, or finances. An order may be very minimal and one size fits all. It may lack in detail, leaving the parties feeling unsure and unguided in how to move forward. Litigation can be incredibly costly. Attorneys bill hourly, and those hours accrue fast when you are waiting in court, drafting discovery and motion papers, meeting with your clients and other attorneys, and certainly if you are preparing for trial. It is not uncommon for the typical litigation to cost tens of thousands of dollars. Lastly, it can be very time-consuming. The court process is slow. It is quite possible that a divorce litigation can take years to complete. And when you're stuck in a process that is largely out of your control, it can really prevent you and your family members from truly moving on. And now I'll turn it over to Catherine Kennedy to discuss the mediation process.
Thanks, Jackie. Mediation is at the other end of the spectrum from litigation. It has become a popular way to separate and divorce outside of the court system. I will provide an overview of the mediation process, why people choose it, and some concerns people may have with the process. A mediator can be an attorney, a mental health professional, or from another profession. They will be working as a neutral in the process, helping to facilitate a couple's conversation. As an attorney mediator, I can't give legal advice, but I can provide legal information. A mediator, unlike a judge or arbitrator, cannot tell anyone what to do, but they can help the couple brainstorm options and can provide examples of what other clients have done. In mediation, while the mediator is in charge of the process, the clients are in charge of the decisions that will be made because they are the ones who know what is best for the family. Mediation is voluntary, and the mediator can't require anyone to continue in mediation. Similarly, the mediator can decide that the process isn't working, and they can choose to terminate the mediation process. So it's voluntary on all sides. Often people are worried that they will have to go through mediation on their own, but in fact, other professionals are often used to support the mediation process. For example, consulting attorneys, family and child specialists, CPAs, and financial advisors can all be utilized by the clients, although unlike in the interdisciplinary team approach of the collaborative process, which you will hear about shortly, they typically do not attend the mediation sessions, instead supporting the clients outside the mediation room. Next slide, please. There are a number of reasons people choose mediation as their process to separate or divorce. I will review the most common reasons. Generally, mediation is the least expensive process option, and this is the primary reason people often choose mediation. But this cost can increase depending on how many other professionals are needed to support the family through the process. People come to mediation because they don't want to fight it out in court. They wish to avoid the us versus them dynamic that we just heard about from Jackie as being set up in the litigation model, and they want to speak for themselves rather than having attorneys speak for them. Preserving the co-parenting relationship is one of the most often cited reasons people choose to mediate, because you can't unsay the hurtful things that may be said during a contentious court battle, and they wish to be role models for their children by showing civility and courtesy during a difficult time. Clients choosing mediation know that if they have children, not only will they always be co-grandparents, they will be co-parents, but they may be co-grandparents as well. Mediation is appropriate for many couples, but not for everyone. I want to highlight a few concerns and how the mediator might address them so that the process may in fact still be successful. The first concern would be if there's a power imbalance in the couple. For example, if one spouse or partner has greater financial knowledge. One of the jobs of the mediator is to help the spouse or partner with the lesser knowledge become more educated. That is, to balance the playing field by encouraging full disclosure, access to information, and the support of a financial advisor if necessary, who may work for both members of the couple as a neutral or only one, depending on the needs of that particular couple. Another concern is if one spouse or partner is indecisive, so they can't make a decision on their own during the mediation process. In this case, a consulting attorney can often help a client who is unsure about their decision-making feel more confident. Recent past or ongoing domestic violence is an example of an extreme power imbalance which cannot be remediated by the mediator. In this case, we typically don't mediate because we don't want one party to capitulate to the other or feel bullied, coerced, or afraid of what might happen to themselves or their children between sessions or after the mediation ends if they don't agree with their abuser or if they try to speak up for what they really want. Last, in order to create a durable agreement that holds up over time, the parties have to make informed decisions. And in order to do that, they have to have all of the financial information that is available. Sometimes people are reluctant to provide that information. While the mediator has no subpoena power the way a court does, the mediator and the consulting attorney can both encourage transparency. The same can be said about the professional team in the collaborative process. With that, I'll turn it over to Teresa Ambris to speak to you about the collaborative process.
Thank you, Catherine. So we've heard about litigated and mediated divorces, but what if you want an amicable divorce, but feel more comfortable having your own lawyer? That's where collaborative divorce comes in. In this process, you and your spouse agree to settle the divorce without going to court. And the attorneys you hire also agree to settle the divorce without going to court. They work collaboratively, using a team of specialists to help with the legal, financial, and emotional aspects of the divorce. People choose collaborative over litigation because they want a peaceful settlement. They don't want to be enemies. They want to be able to co-parent successfully. They also don't want a cookie cutter solution that may have worked for another family but doesn't work for theirs. They want lawyers who will take the time to listen and understand what will work best for their family. The professionals who practice collaboratively are truly dedicated. They come to this work because they have seen the harm that litigation causes. They know that the system is broken and it doesn't always help families. The collaborative team consists of you, of course, your attorneys, a family specialist, and financial specialists. The family specialist can help you create the best way from the very beginning of your divorce to tell your children why you are divorcing or that you are divorcing. That person can also help explain the impact divorce has on children of different ages. And they can help you work out a parenting plan and manage the emotions that come up around that. The goal is to help you co-parent successfully. In some cases, we work with one family specialist. We can also have one for each parent and another one for the children, if that would make sense in your situation. The financial specialist acts as a neutral for both parties and helps gather all of the financial information. This is going to be all of your income, your expenses, your assets, and your liabilities. He or she can help you understand what you will need to be able to live separately. It's usually difficult to support two households on the same amount of money that used to support one. This might mean that you have to look at your budgets and figure out where maybe you can cut expenses or you can increase income. The financial professional will also put together a list of assets with values and a list of debts with values. And that information is all gathered together and shared with your attorneys. And then you work with your attorneys and sometimes the financial specialist as well to find ways to make everybody's needs satisfied, and also to divide up the assets and debts in a way that you all feel is fair. The issues to be resolved in any divorce are how to make decisions for your children, how to spend time with them, how to make sure everyone's supported, and how to divide up the assets. If you think about it, that's really scheduling and math, which are not necessarily difficult. What makes them difficult, some of what Bob talked about earlier, are the emotions, the worry and the concern about the children and the money. Instead of ignoring those emotions, they are addressed in collaborative practice. The family specialist will help you understand and manage them. And instead of being overwhelmed about the money, the financial specialist charts it all out in a way that you can see easily and understand. And then the team works together to achieve the goals that you have talked about from the beginning that are important to you, which leads to a successful resolution. Next slide. Every member of the team helps you identify your individual needs and those of the family and generate options that might fill those needs. We often ask parents, how do you want to remember this time in your life? And how do you want your children to remember this time in their lives? And we think about that and we try to help parents act in a way that supports that. You've probably all heard nightmares about divorce, how contentious and acrimonious it can be, how difficult the lawyers can be, sometimes immersed in their own fight, how long cases can take, and how much they can cost. The collaborative process keeps all of that in check. Imagine instead working with lawyers who are not wasting your time competing with each other. All of the collaborative professionals are respectful of you, your spouse, and each other. Instead of inflaming the conflict, they are skilled at taming it. The collaborative process is thoughtfully, deliberately, conscientiously designed to lead to a successful solution. In collaborative cases, we use a roadmap that the clients are guided by from the beginning to the end. Now, this may sound like common sense, but many lawyers don't have a roadmap. And even if they do, it's unlikely that their adversary would have the same one or even consider using the one he or she has. That's not what happens in a collaborative process. We have a way to get through this process. It's not a negotiation where you start at polar opposites and sort of inch toward the middle. Instead, we thoughtfully identify the needs of each member of the family, and everyone on the team, including you, brainstorms options to fill those needs, discusses them, reviews them, thinks about them, tries them on, and ultimately ends. That's how we ultimately resolve the cases. Now I'm going to pass the mic to Bob Raymond, who will talk more about the reasons people choose collaborative and some concerns. Thank you.
Thanks, Teresa. So now that you've heard how the collaborative divorce process works, let me explain why people choose this model. First of all, collaborative divorce provides the support of highly trained professionals in the three major areas that are part and parcel of the divorce process: legal, psychological, and financial. Experts in each of these three areas work closely with the divorcing couple to clarify needs and goals and assist in developing options for meeting expectations about the future. Second, collaborative divorce offers a way to make the transition from current circumstances to a newly configured way of life in a way that promotes harmony, understanding, and allows for creativity in developing options for meeting goals. Collaborative divorce prioritizes communication between people, and it is often the case that improved communication skills is an unexpected positive outcome of the collaborative divorce process. Third, and perhaps most important, each family situation is unique. Collaborative divorce is based on an understanding that the particular configuration and dynamic of each family is taken into account in a thoughtful and sensitive manner in order to best accomplish a solution and resolution to meet the specific circumstances of the family. This is not a one-size-fits-all process. The fourth consideration for using collaborative divorce is the unique effort that is put into making the settlement agreement long-lasting, meaning durable and strong, in other words, resilient. The settlement agreement addresses how things will be in the near future and will also spell out options for how things can be modified, if need be, as time goes on. Considerations of present and future circumstances are best developed within the collaborative divorce process, where there is an emphasis on clearly specifying current needs and future expectations. Finally, when there are children involved and a parenting plan is developed for time sharing with the children, the groundwork of preparing for successful co-parenting occurs through calm and reasonable conversations, guided by professionals and mentored by the family specialist, who is skilled in assisting parents by laying the foundation for good communication. No other process emphasizes the development of improved communication the way collaborative divorce focuses on this. Concerns about collaborative divorce? Well, people often ask about the cost. Professionals who are involved in the process generally say the cost will be less than a litigated divorce and more than a mediated divorce. It is important to know that there is a value-added dimension to the collaborative divorce process, with the outcome worth the expense. Value added means the quality of the process and the final settlement agreement, which is totally crafted by the divorcing couple with the help of their legal, financial, and family specialist experts, enables people to walk away from the experience feeling more in control of both the process and the outcome. The benefit of having the support and advice of an interdisciplinary team typically assures a settlement agreement for family members with or without children, while addressing individual and collective needs and circumstances. As for how to handle a situation when one's spouse does not agree to the collaborative divorce process, there are several possibilities. One, a disinterested spouse can be provided with reading material to help the spouse familiarize themselves with the way the process works and the benefits of the process. There are short, easy to read articles, as well as clear and informative books, which are generally easy to read and give good descriptions of how the collaborative process works and why collaborative divorce has its advantages. Secondly, an attorney can write a short letter or email to the reluctant spouse, letting the spouse know of your interest in pursuing collaborative divorce and inviting the spouse in for a consultation. And third, you can suggest that your spouse or you and your spouse meet with a family specialist for a consultation during which the neutral professional can explain the process and answer any questions and/or concerns that your spouse may have. Basically, helping to educate your spouse to the benefits and advantages of collaborative divorce often opens the door to a willingness to proceed with the collaborative divorce process. Back to you, Neil.
In this presentation, we have presented information about the three major ways of obtaining a divorce. As I said in the beginning of the presentation, some people divorce using one of these methods without knowing about the other methods or considering which is best for their family. I hope we have clarified this. A word about the presenters. All the presenters are trained as divorce mediators and as collaborative divorce professionals. All have years of experience in their professions. Many of us are experienced in litigation, using the court to structure the divorce and having a trial with the judge making the decision if the litigants are not able to reach an agreement. We all could tell you horror stories about how things can go wrong in court. However, we know that for some families, going to court is the only approach that will work. I believe that we have given a fair and balanced presentation to all the approaches. You've heard Bob talk about the emotions in a divorce and that 90% of the issues in a divorce are emotional. Consider which of these methods is best equipped to handle the emotions that are part of a divorce. We would like to provide you with more information and a further discussion of the issues presented. We plan to offer an open discussion about divorce in the three methods discussed today. If you have any questions about this presentation, contact any one of us. If you have questions that you would like covered in the next presentation, or you would like to be notified of when the next presentation will be held, email me at drneil@mindspring.com. Thank you for taking the time to view this presentation, and I hope the information is helpful to you, your family, and your friends. Thank you.